Hello and welcome to the live broadcast of a special sitting in commemoration of the 50th anniversary of the Eastern Caribbean Supreme Court, right here at Parliament Chambers. This is being telecast through across the 9 member states of the ECSC and was preceded by a church service in all member states. Today's sitting will begin with an address by the Chief Justice, her leadership, the Honorable Dame Justice M. Pereira, and she's not here physically, but the address will be brought by a simulcast video from Antigua. Gathered for today's sitting, we have the Governor General, who is still on the outside inspecting the parade. We also have staff of the Eastern Caribbean Supreme Court, the High Court, District Courts, the Registry. We also have the District Courts, the attorneys at law, judges, magistrates, Queen's Counsels. We also have the Director of Public Prosecutions, Director of the Bodily Correctional Facility, representatives of the Royal St. Lucia Police Force. Addresses will be made by the Attorney General, Mr. Stephen Julian. This address is from the bar. We also have the Director of Public Prosecution, Mr. Dasrian Green, who will be making an address to the gathering here this morning. From the INA bar, Mr. Dexter Theodore. Then we have President of the OECS Bar Association, Mr. Thaddeus Antoine, and also Mrs. Mary Juliana Charles, who is the President of the St. Lucia Bar Association. Ms. Diana Thomas from the Utter Bar will also be delivering an address, followed by an address from the bench from Justice Georges Taylor Alexander, who is an acting High Court judge, to be followed by His Lordship Justice Francis Bell, a senior High Court judge. As you can see that the court of the staff of the Eastern Caribbean Supreme Court and the other attorneys at law are making their way to the Parliament chambers, trying to get seats here. It seems to be a packed audience this morning before the ceremony commences in just a few minutes. But several activities have been planned in commemoration of the 50th anniversary, which began with an essay competition targeting schools on the island. There is also a lecture which will be held this evening, and that will be facilitated by Honorable Justice Don Michel, who is a retired Justice of Appeal. This will highlight the court's challenges and opportunities, along with the role that the court played in the development of jurisprudence in the OECS region since its inception in 1967. The court is headquartered in St. Lucia, it's important to note, and as I said earlier, it was inaugurated on February 27th, to be precise, 1967, replacing the Supreme Court of the Windward and Leeward Islands when the islands began the movement towards political independence from Britain. And the court is being headed by Her Ladyship, Justice Dame Janice Pereira. She's right now, as I said, in Antigua, and in just a few minutes we'll be hearing an address from her, which will be telecast throughout the 9 member states of the Eastern Caribbean Supreme Court. Some of the other activities will include an exhibition at the Castries City Hall, a gala dinner and charity event, and an award ceremony for the essays and poster competition. The Eastern Caribbean Supreme Court has jurisdiction in Anguilla, Antigua and Barbuda, the British Virgin Islands, the Commonwealth of Dominica, Grenada, St. Kitts and Nevis, St. Vincent and the Grenadines, Montserrat, and of course, St. Lucia. While we await the arrival of some of our judges who will be presiding here this morning in just a few minutes. Just to give you an idea of who our presiding judges are, we have His Lordship the Honorable Justice Francis Bell, His Lordship the Honorable Justice Francis Cumberbatch, and now we take you over to the House as the ceremony begins.
We are here this morning as a part of the celebration of the 50th anniversary of the Eastern Caribbean Supreme Court. As part of the sitting this morning, we would first be hearing an address by the Honorable Chief Justice, Her Ladyship, Honorable Dame Janice Pereira, PBE. And thereafter, we will be hearing addresses from the bar, including the Attorney General, Honorable Attorney General, the Director of Public Prosecutions, and from the inner bar, Mr. Dexter Theodore, Queen's Counsel. On behalf of the Bar Association, Mr. Thaddeus Antoine, President of the OECS Bar Association, Mrs. Mary Juliana Charles, and on behalf of the Outer Bar, Ms. Diana Thomas. Thereafter, we'll be hearing from the bench, and we'll be hearing from Justice Georges Taylor Alexander, who will tell us all about the progress of the court as it is situated in St. Lucia. I think then we will start with the Chief Justice's address.
Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court, Their Excellencies, Heads of State of each of the OECS member states and territories, Honorable Heads of Government of each of the OECS member states and territories, retired judges of the Eastern Caribbean Supreme Court, Honorable Attorneys General of each of the OECS member states and territories, Honorable Ministers of each of the OECS member states and territories, Chief Magistrates, Senior Magistrates, and Magistrates of each of the OECS member states and territories, Honorable Speakers of the Houses of Assembly and Presidents of the Senate of each of the OECS member states and territories, Honorable Leaders of the Opposition of the OECS member states and territories, Members of Parliament of each of the OECS member states and territories, Dr. Didicus Jules, Director General of the OECS Commission, Directors of Public Prosecutions of each of the OECS member states and territories, Solicitors General of each of the OECS member states and territories, Mrs. Michelle John Thibbles, Deputy Chief Registrar of the Eastern Caribbean Supreme Court, Registrars as well as Deputy and Assistant Registrars of the Eastern Caribbean Supreme Court, Mr. Gregory Gerard, Court Administrator, and Mr. Francis Letang, Deputy Court Administrator of the Court's headquarters, Mr. Thaddeus Antoine, President of the OECS Bar Association and Presidents of the Constituent Bar Associations of the Eastern Caribbean, learned members of the Inner Bar of each of the OECS member states and territories, members of the Outer Bar of each of the OECS states and territories, members of the Diplomatic Corps, Commissioners of Police and police officers of each of the OECS member states and territories, directors and heads of correctional facilities of each of the OECS member states and territories, staff of the court's headquarters, and the various court offices in each of the OECS member states and territories, distinguished guests, citizens and residents of the Eastern Caribbean, good morning. It is my great honor to address you today as we together commemorate the 50th anniversary of our court, the Eastern Caribbean Supreme Court. The achievement of 50 years as a regional court is by any measure a signature milestone. a milestone for which all of us as people of the Eastern Caribbean, served by our court, share a pride, a sense of pride. After all, the court, as an integral structure of our democratic societies, could not properly function, evolve, and grow without your recognition and acceptance of the requirement of such an institution as the guardian of the rule of law. The theme for the anniversary celebrations of the court, as many of you may know, is Embracing the Past, Celebrating the Future. In keeping with our theme, I intend to use this speech to highlight some of the court's achievements as well as challenges over the past 50 years, and also to speak about the future of the court in seeking to improve the quality of justice for all within our subregion. The Eastern Caribbean Supreme Court is a unique institution with a peculiar history and structure. It is a regional organization within the Organization of Eastern Caribbean States, and alongside organizations such as the Eastern Caribbean Central Bank, it exists, in my view, as a shining example of the possibilities of regional integration. It is a true regional structure, dispensing justice across its 9 member states and territories comprising the OECS. The court was formed at a time when the British colonies of the Caribbean were going through significant political change and taking on greater control of their own affairs. It was therefore only natural and right that a court system be put in place in which the colonies could take control of forging their own destiny, shaped by the norms and values of its people. The birth of the court traces back 50 years from today's date of 27 February 2017. By virtue of and in exercise of her powers under Section 6 of the West Indies Act 1967, an Act of Parliament of the United Kingdom, Her Majesty in Council made on the 22nd of February 1967 the West Indies Associated States Supreme Court Order. This Act of Parliament of the United Kingdom coincides with the period that the former British colonies were being conferred the status of associated statehood with their mother country. The Supreme Court order was therefore a necessary complement of this new status. The court thereby created was then styled the West Indies Associated States Supreme Court. This court replaced the Supreme Court of the Windward and Leeward Islands, which had been established by the Windward Islands and Leeward Islands Courts Order in Council 1959, emanating from the United Kingdom. In a similar manner as the former court, the West Indies Associated States Supreme Court was created as a superior court of record, having unlimited jurisdiction throughout the newly associated states of the United Kingdom, namely Antigua and Barbuda, Dominica, Grenada, St. Christopher and Nevis, Anguilla, as it was then called, St. Lucia, and St. Vincent and the Grenadines. The Supreme Court order also made provision for the court to service the remaining British colonies of Montserrat and the Virgin Islands. It should be noted that Anguilla separated from St. Christopher and Nevis in 1980, having been given its own constitutional charter, and was joined with the other British territories as a member of the court in its own right. Since 1983, the court has been styled in the name as we know it today, the Eastern Caribbean Supreme Court. It continues to have jurisdiction over the same 9 states and territories, save that the 6 states which had earlier achieved associated statehood all moved on to full constitutional independence at various points in time thereafter. In this context, I pause to note that only 5 days ago, the state of St. Lucia celebrated its 38th anniversary of independence from the motherland. At the time of its establishment, the court's headquarters were located in the state of Grenada. The headquarters remained in Grenada up until March of 1979, when, as a result of a change of Grenada's constitutional status brought about by the coup d'etat on the island, the court was relocated to St. Lucia. Between 1979 and 1991, the state of Grenada was no longer a part of the Eastern Caribbean Supreme Court's jurisdiction, as the People's Laws numbers 4 and 14, effected under the Revolution, had established its own Grenada Supreme Court. In 1991, the Constitutional Judicature Restoration Act was passed, and Grenada thereby reverted to the original jurisdiction of the regional Eastern Caribbean Supreme Court, although the former name, the West Indies Associated States Supreme Court, remains. The court's headquarters, however, did not revert to Grenada, but has remained in St. Lucia to this day. The court, as a Supreme Court and Superior Court of Record, comprises 2 tiers, the High Court of Justice and the Court of Appeal. The court's enabling legislation, the Supreme Court order, is protected by the constitutions of the independent member states and recognized by the constitutions of the territories. The constitutional provisions, containing as they do entrenched provisions in respect of the judiciary, thus serve to secure the independence of the court. These provisions cannot be changed at the whim of Parliament. This is important for a number of reasons, but most importantly, it allows the court to carry out its functions without interference and thus ensures that judges can dispense justice without fear or favor. The court is headed by the Chief Justice, who is the President of the Court of Appeal, as well as the person tasked with oversight of the court's administrative functions. The judges of the court sit at the 2 distinct levels. The Court of Appeal consists of the Chief Justice and Justices of Appeal. The judges of the High Court are the Chief Justice, the High Court judges, and masters. Upon establishment of the court in 1967, the first Chief Justice was the Honorable Sir Allen Montgomery Lewis, a national of St. Lucia. Since then, 7 other persons have been appointed as Chief Justice, in addition to a number of acting Chief Justices. All except one has been a national of the ECSC region. I was conferred the honor of serving as your Chief Justice in 2012. Each day I remind myself of the singular honor, the trust and confidence reposed in me to serve the people of our region in this capacity. In 1967, the court was fully itinerant in nature, not only with the Court of Appeal moved between the states and colonies to hear appellate matters, as it still does today, but so too did the High Court judges. They traveled between 3 to 4 different islands for the purpose of conducting criminal and civil hearings. As you would surmise, judicial officers comprised a small group. At the appellate level, there was the Chief Justice and 2 Justices of Appeal, and at the High Court level, just about 5 judges. I am sure that many of you would recall the times when a traveling judge would be presented with a pair of white gloves at the commencement of a criminal assizes symbolizing the absence of any criminal matters to be heard. Today, the appellate level comprises, in addition to the Chief Justice, 5 Justices of Appeal and growing, with a complement of 23 judges and 4 masters at the High Court level. Most of the court's member states and territories now have at least 2 resident judges. In fact, the state of St. Lucia currently has 7 resident judges, 4 in the criminal division, 2 in the civil division, and 1 in the commercial division. This is not surprising, as the state of St. Lucia has the largest population among the OECS member states and territories, and thus by far a larger volume of cases. The Court of Appeal, as I said, remains itinerant in nature, conducting regular weekly sittings in each member state and territory 2 to 3 and sometimes 4 times a year. Additionally, the court hears on average 30 applications at its headquarters in St. Lucia once a month, except during the court's long vacation, and also hears a number of matters via video conference and teleconference throughout the year. Hearings of appeals may also be scheduled during non-sit weeks, depending on the urgency of the matter. The caseload of the court at both levels continues to grow from year to year. This has meant that since its humble beginnings 50 years ago, the court has grown into a large judiciary supported by a distinct administrative arm. In 2003, the Court Administration Department was strengthened with the appointment of a statistician. Prior to this, there was no comprehensive system of compiling and analyzing judicial data from the 9 member states and territories of the court. Nonetheless, the figures from the start of the new millennium are quite telling of the steady increase in the number of matters coming before the court. Just to give a snapshot of the workload of the court at the appellate level, in the judicial 3-year period, 2000 to 2003, a total of 627 cases were filed in the Court of Appeal. Thus, on average, 209 appeals were filed each year. In 2010 alone, a total of 482 appeals were filed in the Court of Appeal. 5 years later, in 2015, this number increased to 507. It should be noted that not only does the Court of Appeal hear matters on appeal from the High Court in each member state and territory, but also from the Magistrates' Court. At the High Court level, over the 2-year judicial period 2002 to 2003, a total of 7,392 cases were filed. In 2010 alone, 7,499 cases were filed in the High Court. In 2015, this number increased to 8,261. As you would appreciate, the ever-increasing number of cases being brought before the court has put tremendous pressure on the court's resources, both financial and human. It is no secret that the court has been plagued with the problem of a backlog of cases. It is a problem that is continually being addressed. The increase in the complement of judges serving the court, as well as the introduction of masters, has aided in addressing the problem. However, there is still work to be done. Recently, in the state of Grenada, the Jurist Project was implemented which significantly reduced a number of long outstanding matters which had been languishing in the court system. Delays in our court system is a multifaceted problem which requires a committed, multifaceted approach to its solution. Progress is being made in other states, and it is hoped with the addition of judges and increasing use of technology that this problem will be a thing of the past. There are other ways in which the court has changed to offer a more efficient service to the citizens of the region over the years. Changes in the court structures have been brought about and are still being developed with a focus on specialized divisions manned by dedicated judicial officers. Criminal divisions are in operation in a number of our states. 2 of our states have commercial divisions, a carve-out of the general civil division. Considerable efforts are underway for establishment of family divisions in other states. Other specialist divisions will no doubt follow as the court develops and finds new ways of adapting to new challenges presented by the growth and evolution of modern societies. This increasing specialization of the court means that the court is able to allocate resources more efficiently and provide a better service to the public. The court also had to implement changes to its procedures so as to improve its effectiveness. To my mind, one of the most significant advancements in recent years in the court system was the introduction of the Civil Procedure Rules 2000. Whilst the CPR 2000 may not be a perfect set of rules and will constantly need to be reviewed for improvements, the implementation of the Civil Procedure Rules vastly improved and streamlined the civil litigation process. Thus, we went from a system where lawyers were able to dictate the pace at which a cause proceeded in the court system to a court-led process, providing timelines from the filing of a case to trial. It gives the court the ability to effectively manage cases to ensure that matters are disposed of in a timelier manner. The Civil Procedure Rules 2000 also aided in the ushering in of the office of Master of the Supreme Court to improve the management of cases in the civil division of the court. Today, we have also introduced a Master in the criminal division currently serving the state of St. Lucia. It is my hope that as more modern rules of criminal procedure are introduced in other member states, that advantage can be taken of the utilization of masters for speedier processing of criminal cases before the court, leading to more timely and effective dispositions. Another of the court's successes has been in the area of alternative dispute resolution, specifically court-connected mediation. In a number of states, this method of dispute resolution has been a resounding success. It provides an excellent alternative means by which parties can meet and resolve issues outside of the court system. It is of course significant that in the powers given to judicial officers under the Civil Procedure Rules, one of those is the power granted to judicial officers to actively encourage and assist the parties in reaching a settlement of their cases on terms that are fair to both. This is a useful and important power which every effort is being made to enhance and encourage its use. Mediation is not mandatory, at least not yet. Nonetheless, it provides an avenue to ease the burden on the court system and have matters resolved amicably, finally, more speedily, and I may add, with less cost. The hope is that alternative dispute resolution can become an even greater part of the tools employed by the court to ensure that justice is done between parties and at a much earlier stage. Other forms of alternative dispute resolution, or ADR, also hold promise for the public, and the court should be a leader in developing and encouraging new tools with which greater benefits can be derived. Another such tool is arbitration. The consideration of adopting modern arbitration regimes throughout our region as an alternative for the resolution of commercial disputes is a positive step. The territory of the Virgin Islands has recently established a state-of-the-art international arbitration center. Members of the bar in other member states and territories are also engaged in efforts to establish arbitration bodies to deal with commercial disputes. The court welcomes these developments. I believe that one of the most important developments in the court over the years is how we have been able to embrace and harness changing technology. So far, the court has been able to fully integrate digital audio equipment in courtrooms throughout its member states and territories. This has made the production of transcripts of proceedings and the review of evidence much more efficient, once again saving the court and all the other parties involved precious time and money. The court has also been able to make use of video link technology, which has proven to be especially useful in the hearing of criminal matters. For example, in St. Lucia, matters are often heard via video link from the Bordelais Correctional Facility, avoiding the need to transport inmates from the facility, which is quite a distance from the courthouse in Castries. This not only saves the court time and avoids the transportation expense to the correctional service, but it also serves as a safety measure by avoiding potential security breaches. In Antigua and Barbuda, the government has implemented the legislative framework to allow for evidence to be given via video link. This saves tremendous expense to the prosecution service and avoids delay in the hearing and determination of matters if a witness cannot be present in court. One area of technology that offers great potential to the court is that of electronic filing of documents. Presently, a rudimentary method of e-filing is used at the appellate level of the court for appeals from the Commercial Division of the High Court in the territory of the Virgin Islands. In my opinion, electronic filing and case processing has the ability to revolutionize the way in which the court carries out its business, given the reality of a regional court comprised of a group of islands. My fervent hope is that in the near future, a state-of-the-art e-filing system with a fully integrated modern e-case management system will be rolled out across all member states and territories at both levels of the court. The financial and other benefits to the court, the people, and the states and territories of such a move would be tremendous and enduring. I, along with all the officers of our court, as well as our court users, are committed and anxious to move forward to this new stage. It is the modern way of doing business. It facilitates the ease of doing business and should be no less so for doing business with the court. Whilst the benefits of such e-technology are apparent, the cost to implement may be considered as being high. In reality, it is not, as the long-term benefits to be enjoyed far outweigh the cost of implementation. I accordingly urge all of our governments to fully support our efforts toward achieving an e-judiciary as the next milestone in the court's strides to continuously improve the quality of justice to our people. I cannot stress enough how important technology is and will continue to be to the workings of the court. Although our law and legal system is deeply steeped in tradition, one cannot deny that in order to dispense justice in a modern world, the court itself must be modernized. The Eastern Caribbean Supreme Court as an institution has continued to be a shining example for courts all over the world. We must do all within our power to maintain and, if anything, to improve upon that image. Critically, all must be done to ensure it is not diminished or lost. Despite the several challenges, the court has always strongly guarded its role as the protector of the rights of the citizens of the OECS region and the preserver of the rule of law. The court has been able to fulfill this role with utmost integrity and pride throughout its 50 years. A plethora of cases come before it, ranging from constitutional and election matters to big money commercial disputes. These matters have been presided over by some of the finest jurists, not only in the Caribbean, but the world over. There are several landmark cases that have cemented the court's contribution to the Caribbean region and beyond. The area of constitutional law has highlighted the court's role as a check on the exercise of the powers by the executive. Many of the court's decisions have upheld the principles of the separation of powers in seeking to protect and preserve the balance between the judiciary, the executive, and the legislature. Such cases guarding the rights of citizens include Benjamin and others, and the Minister of Information and Broadcasting and another from Anguilla. The case concerned the fundamental right of freedom of expression. The matter went to Her Majesty's Privy Council, which agreed with the decision of the High Court Judge, Saunders J. as he then was, that the government's actions of suspending a radio program was a breach of the fundamental right to freedom of expression enshrined in the Anguilla Constitution Order. The case was followed by a long line of subsequent cases on a similar issue. In the area of the criminal law, the Queen and Hughes emanating out of St. Lucia is particularly noteworthy. It was the first successful challenge to the inhumanity of the mandatory death penalty in the Commonwealth Caribbean. The court boldly moved in a direction where it refused to be bound by older cases which imposed harsher and discriminatory sentences which were increasingly viewed as being in violation of human rights standards. At the High Court, Saunders J. held that the mandatory death penalty was unconstitutional as it infringed on the constitutional protection against inhuman treatment. The decision was upheld by the Court of Appeal, which identified mitigating factors that should be taken into account by a jury in deciding the imposition of such a sentence. The Privy Council essentially agreed with the Court of Appeal, but found the judges, not juries, should determine whether a crime was deserving of a death sentence. This decision did away with the automatic passing of a death sentence upon a person convicted of murder, regardless of mitigating factors, and brought it into the purview of the exercise of discretion by a judge. A line of cases which followed set down guidance which to date the courts follow after a person is found guilty of the crime of murder. Notable among them is the Court of Appeal case of Mitcham and the DPP out of the state of St. Christopher and Nevis. In the area of matrimonial law, one of the most important cases from the jurisdiction is the case of Stonich and Stonich, an appeal of the decision of the High Court judge in the territory of the Virgin Islands. The seminal case laid the foundation for the application of the Matrimonial Proceedings and Property Act in many of the member states and territories of the court. The overarching principle of the case was that in apportioning matrimonial property, the court must first and foremost ensure that the overall objective of fairness is met. This was a shift from the then common approach of courts regarding the contributions of the main money earner in a marriage, which was often the husband, to be more valuable and more important than the child rearing and homemaking responsibilities, which were often undertaken by the wife. This was a signal shift in the court's approach to gender equality. With the advent of the Civil Procedure Rules 2000, a number of decisions delivered by the court brought clarity to the rules by ensuring their interpretation within the cardinal principles of fairness and due process. Such decisions include Blaise and Bernard Lamoth out of the state of Grenada, and C.O. Williams Construction St. Lucia Limited and Inter-Island Dredging. There have also been several judicial review matters which have been decided by the court as the public has become more and more aware of their rights and interests in public law matters. I could go on and on highlighting a number of decisions that have shaped the jurisprudence of the Eastern Caribbean, but time does not permit such. However, I should make special mention of the increasingly high value commercial matters that have been decided by the court, largely emanating from the territory of the Virgin Islands. These cases are often extremely complex and intricate and involve areas of law that would not ordinarily be experienced in the normal course of disputes in our region. The court, however, has been able to tackle these matters, delivering robust, high-quality decisions, of which many are upheld by the final appellate court. It is my view that the court, with its comparatively small contingent of judicial officers, coupled with other constraints, has served this region remarkably well over the last 50 years. In many countries in the world, reports abound of judicial systems where corruption is said to be endemic, and for these reasons, as well as others, many choose our system for the resolution of disputes. This is a testament to the overall fairness and integrity of our system. It is of course true that there have been instances when our justice system and judicial officers have been questioned. This criticism and analysis, however, has been either about delays or a decision being unfair because the losing party is unhappy with the result. For 50 years, the Eastern Caribbean Supreme Court has been able to dispense justice with the highest degree of integrity, and the court remains steadfast in ensuring its independence. It is little wonder that the court is often referred to as a model regional court. The court, as our mission statement says, strives to serve its member states and territories by providing access to a system of justice that is fair, effective, and efficient. Though not perfect, the court works tirelessly every single day to achieve just that. It is also true to say that the work of the court often goes unnoticed or is not always understood. This is no doubt in part due to the very nature of the judicial role and the need to exercise great care in all that is said and done. A form of judicial reticence and restraint is necessary in the due administration of justice. However, more can be done to ensure that our people understand who we are and what we do, so that our people, armed with more knowledge, can have greater confidence in the justice system. The court is now placing greater focus on bridging this information deficit. To this end, a number of activities are being undertaken as part of these 50th anniversary celebrations with the object of reaching out to the wider society and particularly targeting our public education efforts at schools. As many persons may have observed, we have been tweaking our website in the hope that it provides a more user-friendly experience. We hope to use this platform even more so to share information about the work of the court and other matters of interest. Our court has a rich history. It continues to enjoy an important place in our societies. As the court moves forward, let us all join together in celebrating the past and embracing all that will in the future shape, build, and continually enhance the rich tapestry of our court for our benefit and for the benefit of generations to come. Finally, may the blessings of the Almighty continue to strengthen and guide us as we move forward together. I thank you.
We shall continue the proceedings with thanks to Her Ladyship Honorable Dame Janice Pereira for that very extensive address on the progress of the court for the last 50 years and conveying the slogan basically that is being used for the 50th anniversary, celebrating the past and embracing the future. So as we proceed, we would continue to celebrate the past and embrace the future. And I am told that we would start with the address from the Honorable Attorney General this time.
May it please you, my Lord, my name is Stephen Julian, and I appear before you as the Attorney General of St. Lucia. His Lordship, the Honorable Justice Francis Bell, High Court Judge. His Lordship, the Honorable Justice Francis Cumberbatch, High Court Judge. Her Ladyship, the Honorable Justice Katie Centruz Albertini, High Court Judge. Her Ladyship, the Honorable Justice Kimberly Snack Fulgence, High Court Judge. His Lordship, the Honorable Justice Godfrey Smith, High Court Judge. Her Ladyship, the Honorable Justice Vivian Georges Taylor Alexander, High Court Judge. Her Ladyship, the Honorable Master Agnes Acti, High Court Master. With your leave, my Lord, I recognize the presence of Her Excellency Dame Paulette Louise, our Governor General. Mr. Justice Michael Gordon, Retired Justice of Appeal. Madam Justice Jennifer Remy, Retired High Court Judge. The Honorable Senator Hermangill Francis, Minister of Home Affairs, National Security and Justice. The Honorable Leon Theodore John, Speaker of the House. The Honorable Andy Daniel, President of the Senate. Dr. Didicus Jules, Director General of the OECS. The Honorable Sarah Flood Bobra, Minister in the Department of External Affairs. Your Honor, Christine Fulcher, Senior Magistrate of the 1st and 2nd District Courts, and all other magistrates of the 1st and 2nd District Courts. Mr. Dazrian Green, Director of Public Prosecutions. Mr. Thaddeus Antoine, President of the OECS Bar Association. Ms. Mary Juliana Charles, President of the St. Lucia Bar Association. Dr. Cordelia Ambrose, Permanent Secretary, the Department of Justice. Mrs. Sonia Augustine Monrose, Deputy Permanent Secretary, the Department of Justice. Mr. Don Louisi, Budget Director. Ms. Brenda Portland Reynolds, Solicitor General. Mr. Vern Gard, Director of Bordelais Correctional Facility. Mrs. Sharon Gardner Hippolyte, Registrar of the High Court. Mr. Jan Soufflé, Deputy Registrar of the High Court. Mr. Stephen Brett, Deputy Director of Public Prosecutions. Mr. Chris Felix of the Bordelais Correctional Facility. Members of the Inner and Outer Bar, staff of the Registry of the High Court, Court of Appeal and District Courts, staff of the Department of Legal Affairs, representatives from the media, ladies and gentlemen, good morning. I am humbled by the privilege of addressing this August Assembly on the occasion of the golden anniversary of the Eastern Caribbean Supreme Court. With the usual celebrations which will undoubtedly attend such milestones, must come the counterweight of introspection and reflection. My introspection began in earnest whilst I listened to Madam Chief Justice at the opening of the law year. Therein she presented in high resolution an image of the state of affairs of our judicial system. As she listed the successes and challenges of our system, I sensed dignified exasperation when she said, and if you'll leave, my Lord, I quote, "For far too long, the judiciary has been made to make do with precious little, while at the same time the citizenry hold great expectations," end quote. This resonated with me, as at the time I was in service as a magistrate and well acquainted with the peculiar challenges of this office. But how did it come to this? Was this always the case? I wondered what were the coordinates of our first Chief Justice, Sir Alan Lewis, as he leaned forward and stepped onto the first cobblestone to face the challenges 50 years ago. For this, I sought the historical record of the first sitting in St. Lucia, which I found compliments of the National Archives. It is contained in the Crusader Sunday Morning News for Sunday, the 30th day of April, 1967. With your leave, my lord, I wish to refer to the article contained on the cover page of the said newspaper. Therein, Mr. Justice Allen Lewis, Chief Justice as he was called then, is recorded to have said the following: that it was their intention to build confidence in the courts, and in so doing, he expected the confidence of the people. It was the purpose of the court to deal expeditiously with its business, and that he hoped that confidence and respect will be built up by excellence in judicial reasoning, and thus gain the respect of the courts in the Caribbean. The courts were charged with the interpretation of the Constitution and the protection of the freedoms granted by the Constitution. The task before them was not an easy one, because these tasks were standing at crossroads. He, however, expected the cooperation of the public at large. We will endeavor to earn the respect of the public, and we expect respect from them, went on the Chief Justice. In the discharge of their duties, we expect the assistance of the bar, and the greatest assistance that can be given to the bench is when counsel come well prepared to present their cases, end quote. Not surprisingly, we find the striking similarities in content even after 50 years. But I ask, could the learned Chief Justice Lewis dare perceive that the court would mark its golden anniversary in borrowed premises? Or that his successors would simply have to make do? How can the court serve as our sentries for the preservation of the rule of law when they struggle for resources? We need only tune in to the news to hear of the daily onslaught on the courts as persons cry out for justice. The irony is that over the years, this perception has been fueled by those who determine the allocation of resources. Civil society must acknowledge that an undersubscribed judiciary is incapable of serving as our collective shield against the abyss of dystopia. Members of the bar must also appreciate their role in this play. They are the first line of defense against any assault on the rule of law. We must bring our insight and expertise to bear on matters of national interest, as it is our civic duty so to do. We must serve with the highest standard of professionalism and strive to earn the confidence of the citizenry. Do not underestimate the power of the citizenry. They will support their champion and lend their voices to the chorus for greater support for the judiciary, but only if we stand with them. I note the commendable efforts of some members of the bar, including Madam President. They need your support. Be generous with your time and raise the profile of the profession. In time, I plan to meet with our executive so that we may gain a greater appreciation of the areas for mutual support. As one of your number who has served on the bench and now sits in cabinet, I am aware that I am uniquely poised to advocate on matters which affect the court. I have accepted the baton from our predecessors, and I'm resolved to contribute to the development of our profession. I am convinced that before we embark on any grandiose adventure, we in St. Lucia must first get our judiciary working at an acceptable level. We must simply get it right. In furtherance of this, I have formed a strategic alliance with the Minister of Legal Affairs and the Director of Public Prosecutions. We have met and addressed the Honorable Prime Minister Alan Shasley on a myriad of issues, including but not limited to legislation and matters which affect the court. I can also report that I have received a commitment from the Honorable Prime Minister who assures that law and order and justice is a top-tier priority for his administration. I expect that he will articulate his plan at the appropriate time and forum. In closing, I invite all of you to join Madam Chief Justice as she leads the drumbeat for improvements until the sound of the falling tree in the forest is heard. And that was her quote. I also express my profound gratitude for everyone whose work contributes to the functioning of the judiciary. Your effort and sacrifice is acknowledged and worthy of celebration. I wish you, as we say in St. Lucia, bon fête, happy 50th anniversary, and God bless. If I can be of any further assistance, my lord, I take my seat. Thank you.
Thank you very much, Honorable Attorney General, Mr. Stephen Julian. We shall now hear from the Director of Public Prosecutions, Mr. Darjan Green.
May it please you, His Lordship, the Honorable Justice Francis Bell, His Lordship, the Honorable Justice Francis Cumberbatch, Her Ladyship, Honorable Justice Caddy St. Rose Albertini, Her Ladyship, the Honorable Justice Kimberly Snack Filgens, His Lordship, the Honorable Justice Godfrey Smith, Her Ladyship, the Honorable Justice Vivian Georges Taylor Alexander, Her Ladyship, the Honorable Master Agnes Acti. With your leave, I wish to recognize the presence of Her Excellency Governor General Dame Paulette Louisi, the Honorable Leon Theodore John, Speaker of the House, the Honorable Andy Daniel, President of the Senate, Dr. Didicus Jules, Director General of the OECS, the Honorable Herman Ginn Francis, Minister for Home Affairs, National Security and Justice, the Honorable Stephen Julian, Attorney General, Your Honor Christine Fulcher, Senior Magistrate, and all magistrates of the First and Second District Courts, Mr. Thaddeus Antoine, President of the OECS Bar Association, Ms. Mary Juliana Charles, President of the St. Lucia Bar Association, Dr. Cordelia Ambrose, Permanent Secretary, Department of Justice, Mrs. Sonia Augustine Monrose, Deputy Permanent Secretary, Department of Justice, Mr. Don Louisi, Budget Director, Ms. Brenda Portman Reynolds, Solicitor General, Mr. Milton Daisy, Acting Police Commissioner, Mr. Vern Gard, Director of the Baudelaire Correctional Facility, Ms. Sharon Gardner Hippolyte, Registrar of the High Court, Mr. Jan Siffley, Deputy Registrar of the High Court, Mr. Stephen Brett, Deputy Director of Public Prosecutions, Mr. Leon Terrence, Deputy Director of the Baudelaire Correctional Facility, members of the Inner Bar and Outer Bar, staff of the Registry of the High Court, Court of Appeal and District Courts, staff of the Department of Legal Affairs, representatives of the media, ladies and gentlemen, good morning. On this day, in the year 1967, marked the genesis of a great institution, the Eastern Caribbean Supreme Court. These 9 contracting members embarked on this journey through the uncharted waters of time. Here we are, 50 years later, and indeed we can safely say that amidst the uncertainty, the trials and tribulations, there is overwhelming reason to celebrate the golden anniversary of this court. The court's mission statement is to serve its member states by providing access to a system of justice that is accountable and independent and administered by officers in a prompt, fair, efficient, and effective manner. But for the term efficient, I can safely submit to you that I am of the view that this honorable court has met its goals thus far. However, I wish to stress that it is through no fault of its own that this prized and cherished institution finds some of its members wanting with regard to the efficient and timely dispensation of matters arising before the courts. This notorious backlog, at first blush, is seen by members of society as being the fault of the judiciary. I wish to submit that this is clearly not the case. May I refer, my lords, my ladies, to our Chief Justice's opening address, marking the opening of the new law year 2014-2015, delivered on the 17th of September 2014 in Anguilla. At page 4, commencing 4 lines from the bottom. May it please you. Our Chief Justice stated, and I quote, "Our court is also guided by the Latimer House principles, which provide an excellent operational manual of good practices governing relations between the executive, parliament, and the judiciary. The principles state, among others, that the adequate resources must be provided for the judicial system to operate effectively without any constraints which may hamper judicial independence. Sufficient and sustainable funding should be provided to enable the judiciary to perform its functions to the highest standards, and appropriate salaries and benefits supporting staff, resources, and equipment are essential to the proper functioning of the judiciary. The Latimer House principles also acknowledged the judicial independence and delivery of efficient justice are important for maintaining the balance of power between the three arms of government. This excerpt, in my humble view, is so appropriate to the theme celebrating the past, embracing the future. If it is indeed expected that the court shall continue to strive for excellence, there must be the support of the governments of the member states. In this state, we are experiencing a great backlog, as we have clearly acknowledged, in cases in which the greater part, the result of the deficiency, is in housing for the courts. We recognize for the first time that we have the ability to simultaneously operate 3 high courts for the hearings of criminal matters and an additional for the purpose of case management. However, we lack the proper accommodation to fulfill this vision. This ought not to be. I humbly call upon the executive to put justice first, so that this honorable court can fulfill its vision statement, which is the achievement of professionalism and excellence in the timely, effective, and efficient access to and administration of a cohesive, independent, and accountable system of justice for the benefit of its member states. Having said this, it is with great honor and pride that I stand before this court in the capacity of the Director of Public Prosecutions and congratulate the Eastern Caribbean Supreme Court for its stellar performance throughout the years, the last 50 years that is, and I am certain that the following 50 will be met with the blessings of the Almighty God, as so I am so proud that we continue to be God-fearing. The Almighty has asked us not to worry about tomorrow, for tomorrow will worry about itself. Each day has enough trouble of its own. I humbly submit that my office is dedicated to doing its part to assist in the continued growth of this honorable court. Let us all do our best to achieve this common goal. May it please you, my lords and my ladies, this ends my submission.
Thank you very much, Mr. Darshan Green, Director of Public Prosecutions. In introducing the next speaker, a very brief story where I attended some years ago a meeting of the International Bar Association and sat next to some delegates from certain states in Africa. And on questioning them about their attitude towards a very aging elder statesman in Africa, the individual who was next to whom I was sitting just looked at me and answered me in this way: in Africa, we respect our elders. That was the end of the story. In St. Lucia, we respect our elders as well. And even though the next speaker's name was left out of the program, we have included him. Therefore, I will call upon Mr. Kenneth Momplessis, Queen's Counsel, to be our next speaker.
I'm grateful, Your Lordship, for allowing me to say a few words. And before I begin, may I adopt the long protocol list which has been repeated, and I don't think you wish me to repeat that, except, of course, to acknowledge the presence of our Governor General, whom we all adore, and other members of the government. My Lord, when I was not asked to say a few words today, I thought it a little difficult that I have been left out. Now, I will say this because this is a special occasion. And I was told, well, we're giving you a rest. My thoughts then turned to the fact that just as a stain or mark is on a fabric and remains there so long that it forms part and parcel of the ingredients of the fabric, I thought I was placed in that situation. So, out of respect, and I hope you don't think me indiscreet, I would like to say a few words. I'm the longest serving Queen's Counsel in this part of the world. I qualified at Gray's Inn, and in July this year, I will have been 60 years in private practice. The two other members who qualified with me have long passed. Henry Girodi and Thomas, Mr. Adams, Thomas Adams. Anyway, they were long gone. These were, I can remember, there are only 3 Caribbean people that qualified at Gray's Inn on that occasion. So when you get me to stand up, because I want to say something special, the OECS, before we started our judicial situation, we had to choose a person in charge of it, supreme. It was difficult. At the time, we wanted a Caribbean person of the area, and the most fitted person at the time was Sir Alan Wiss. But Sir Alan was, at the time, on the Court of Appeal of Jamaica. Unfortunately for us, when it became necessary to choose a person to rule in Jamaica, it was said that he was not a Jamaican. Although, at the time, the bar of Jamaica felt that he was the most appropriate and qualified person to be. Well, his disappointment was our gain, because when the job was open, he was offered the position and he gladly accepted. Sir Alan was a man of tremendous character, and his character was put to the test when Robert Bradshaw did something which allowed Sir Alan to express the rule of law and the independence of the judiciary. Let me explain how it happened. Robert Bradshaw, the president or prime minister at the time of St. Kitts and Nevis. At the time, St. Kitts and Nevis was St. Kitts. They had an administrative section of St. Kitts, Nevis, and Anguilla. The Anguillians always felt that Bradshaw was a man of dictatorial characteristics. And they rebelled because they felt that he was not attending to them. That is why the British had to go into Anguilla, and Anguilla became separate. But the story I'm about to give was not to indicate the character of Bradshaw. Justice Glasgow had to make an unfortunate decision against the government which affected the government of St. Kitts Nevis. And poor Justice Glasgow, didn't he pay for it? The orderlies were removed from him, and he suffered a lot of privation as a result of the decision of Bradshaw. Sir Alan decided that he would put a stop to it and any other person who attempted to interfere with the independence of the judiciary. In those days, Liat, as good as it is now, wasn't as good as then at all. So Sir Alan chartered a flight and had a special sitting of the Court of Appeal and dressed Bradshaw down and put him in his place. I was too late to find the statement made by Sir Alan, but I think we should all try and read it. I'm going to get a copy and circulate it to you. It was very, very interesting. Sir Alan was a serious, and he is the one that brought to me the standard that we now enjoy from the judiciary. He blazed the trail for that standard. I can recall having battles with my colleague's father, Kenneth Foster, and one of our first cases in the Court of Appeal was Sir Alan, and it was a case of an accident by a car. I won the case, and Kenneth Foster decided to appeal. And he took the argument of contributory negligence. And Sir Alan says, who gave the decision, in among other things, says, we've had contributory negligence in our code long before the act came in England. He who has fault has to assess whatever fault it is, and that's a form of contributory negligence. So we had a good example of leading the judiciary in the Caribbean. There are many areas that we have to surmount, but there are many areas with which we have got through. I would like to see two things. I would like to see the system in St. Lucia, at least, the system of notaries and giving them their responsibilities. Today, our St. Lucia lawyers automatically get the significance of being a notary, none of which they know anything about. It's not taught in the schools, in the university. I think we should know something about it. Secondly, I think we should have a system whereby we have young lawyers qualifying should have a sense of pupillage before they become exposed to the public to earn their money properly. I have notes in my head, but I want to stop because there's a lot more I could say, but I'm not ready for that, except to say, Lord, I'm very grateful for allowing me at this stage to express a few words and to give this community here, my legal fraternity, a bit of the past. Thank you.
Thank you very much, Mr. Kenneth Montplaisir, Queen's Counsel, and I'm sure that at some later date you will be given an opportunity to say a lot more, especially on that very burning topic of the relationship between the civil code and the common law and the challenges that it sometimes presents for those of us who have not been trained in the civil code and have to adjudicate here and learn it as we go along. Thank you very much for your contribution over the last 50 and indeed to be soon 60 years. I congratulate you for everything that you have contributed, Mr. Montplaisir. We call upon next Mr. Dexter Theodore, Queen's Counsel, to speak on behalf of the Inner Bar as well. Thank you.
May it please the court, may I be permitted to adopt the protocol list established by the speakers before me, subject, of course, with the court's leave, I wish to recognize the presence of Her Excellency Dame Pearlette Louisy, our esteemed Governor General, retired Justice of Appeal, Michael Gordon, Queen's Counsel, and retired Justice of the High Court, Jennifer Remy. It is my distinct pleasure to rise on behalf of the Inner Bar to express felicitations to this honorable court on the occasion of this, its 50th anniversary. The court was proudly established, as we have all heard, in 1967 by the West Indies Associated States Supreme Court Order number 223 of 1967. It is a superior court of record for 9 member states of the Organization of Eastern Caribbean States, and of those, Antigua and Barbuda, Dominica, Grenada, St. Kitts Nevis, St. Lucia, and St. Vincent and the Grenadines are independent states, and 3, namely Anguilla, the British Virgin Islands, and Montserrat, are British overseas territories. The first 3 judges of our Court of Appeal were Justice of Appeal P. Cecil Lewis, and the legal luminaries and sons of the soil, the Honorable Chief Justice, as we know and have heard a lot about, Sir Alan Lewis, and Justice of Appeal Keith Gordon. All told, we have had the privilege of being led by 12 illustrious Chief Justices, 5 of whom have held acting appointments, with our current President, Her Ladyship, the Honorable Dame Janice Pereira, DBE, being our first female Chief Justice. I have hazy recollections of a time over 30 years ago following my admission to the bar when Sir Lascelles Robotham was our Chief Justice. In those days, the office of the Court of Appeal comprised hardly anything more than a cubicle or two, manned by the efficient Miss Dean, working away tirelessly on her trusty typewriter and duplicating machine. Now the court's head office at the Heraldine Rock building on the waterfront houses the Justices of Appeals Chambers, the Court of Appeal Registry, the Judicial Education Institute, the Court of Appeal Library, and the Administrative Department of the court, manned by a formidable battalion of specialist staff who all perform vital services that ensure the smooth running of the court. In the old days, we were served by one puny judge. In my early days at the bar, Justice Horace Mitchell was the judge assigned to St. Lucia. He held court in the main courtroom back on Pania Street, switching with ease from civil hearings to criminal assizes and back again. In those days, civil proceedings were guided by the rules of the Supreme Court, which were passed in 1970. With the turn of the century came perhaps the most exciting time in the life of our court, with the introduction of the Civil Procedure Rules 2000, which helped us to entirely reshape the jurisprudential landscape of these islands. The court, led by Sir Dennis Byron, realized that it was imperative to ride the technological wave if the court were to truly live out the letter of its mission statement of providing access to a system of justice that is administered in a prompt, fair, efficient, and effective manner. The Judicial Enforcement Management Systems, GEMS, technology, which Sir Dennis ushered in, has greatly enhanced the court's capacity to better manage cases electronically and lessen the need to handle physical files. The court is also to be commended for introducing recording equipment into our courtrooms. This is complemented by the Liberty Note software that allows the judge to create notes on his laptop while the proceedings are being recorded. Those notes may be easily synchronized with the court recording, affording the judge the facility of instantaneously jumping from note to note and corresponding audio of the trial. All the judge need do during the trial is to record his notes into his Liberty Note software, and at the end of the day, call for the court recording, and with a click or two, sync it into his Liberty Notes application on his laptop. Once synced, the judge can jump to and listen to the audio of any part of the trial with a click of a button. The judge's notes of the proceedings can be as detailed or as brief as he wishes. Proper use of this technology can result in 2 trials being effortlessly conducted in a single day. So in a sense, the future of our court is already here, but it is imperative that we all embrace it. In the last 5 years or so, we have endured the inconvenience and indignity of becoming a peripatetic court, unceremoniously shoved from one venue to the next, as mold and other vermin infestations expose the neglect that has been over the decades visited upon this, the third arm of government, by the wealthier executive arm. Much has already been said about the need to build state-of-the-art halls of justices in our islands, which would rid us of the innumerable problems plaguing our decaying infrastructure. But perhaps what is going on unnoticed is that the dislocation and attendant adjournments over the years have insidiously threaten to return us to the pre-CPR days of unmanageable backlogs. Decisive action is necessary to arrest the slide. Although the technology has been with us for years, not all of our judges have made full use of it, as they should, if we are to truly make strides towards reducing the backlog. The court, however, must push ahead, undaunted, along the path of modernity, even if it means having to drag along any reluctant judicial officers, kick and scream as they might. A modern court's future is undoubtedly inextricably linked to technology. Whether we want to admit it or not, in the court, paper is the bane of our existence. How many times have our clients traveled from overseas to attend court only to be told that the court has misplaced the file and the matter has to be adjourned? The rest of the world is moving towards a paperless environment, and if we are to be serious about increasing the efficiency of our courts, we must give serious consideration to making full use of GEM's e-filing capabilities. We must also be prepared to consider moving on to more efficient case management systems when we outgrow GEMs. Forward-thinking courts around the world are making more and more advances in e-filing and are now holding e-trials. For instance, in Queensland, Australia, litigants may, usually at the case management stage, ask for an e-trial of their matter. To facilitate this, documents are converted to an electronic format and numbered as multi-page searchable PDFs, and the parties burn their trial documents to CD or DVD and deliver them to the court office. An e-trial is conducted in much the same way as a paper-based trial, with the main difference being that documents are submitted and viewed electronically during the trial. This is something that we can do. When lawyers and litigants enter the precincts of the court, they should be able to view real-time case status screens so that they can know what cases are scheduled on that particular day and at what times they will be heard and in which courtrooms. This is particularly relevant when courtrooms are housed in different buildings if we are to avoid catastrophes like litigants waiting at Naira Court for an entire day for their case to be heard while it is being heard behind their back at La Place Carénage. Modern systems have the capability to automatically send text messages to litigants reminding them of the next hearing date of their matter. Too much time is wasted because of clumsy calendaring mix-ups. In its ultimate form, e-filing will result in attorneys being able to share documents with the court and with each other in real time in a secure environment. We have already made tremendous advances in the field of video conferencing, especially in the criminal jurisdiction of the court, where, as we have also heard, it is possible in St. Lucia for inmates at the Borderley Correctional Facility to be given their day in court without the state incurring the expense and wading through the security protocol associated with transporting them all the way from Dennery. But more needs to be done. It is time that video conferencing becomes a standard resource of our courts. In the future, lawyers should be able to attend court from remote locations, and all or at least certain select open court hearings should be streamed live on the internet, as has already been embarked upon by the Judicial Committee of the Privy Council. We all know of the delays being currently experienced with the transcription of court proceedings. The court must explore the possibility of investing in voice recognition software coupled with a virtual transcription service to transcribe hearings in real time. The court must in time if it has not already done so, consider storing data and documents in secure private clouds with battery backups and standalone capability to guard against power and network failure. There are certainly exciting times ahead if we are brave enough and willing to do what it takes to make ourselves sufficiently tech-savvy to embrace them. I say, let's do it. Our court has shown an amazing durability and adaptability over the years, and on this, its golden jubilee, I am confident that this future looks bright as it will only continue to grow from strength to strength. In that regard, I pledge on behalf of the Inner Bar our commitment to do whatever we can to ensure the continued success, relevance, and viability of the court in the changing times that lie ahead. May it please the court.
Thank you very much for that, Mr. Theodore. I recommend you as a recruit to Mr. Ernest at the Court of Appeal. I hope Mr. Ernest is listening very carefully. Next, we will have, and I thank you very much, Mr. Theodore. Next, we would have Mr. Thaddeus Antoine, President of the OECS Bar Association, to address the court.
May it please you, my lord, my ladies. My lord, with your leave, I would like to adopt the protocol list so extensively presented by your lordship. But it would be remiss of me not to recognize Her Excellency Dame Paulette Rizzi, Governor General of St. Lucia, Mr. Michael Gordon, Queen's Counsel, retired Justice of Appeal, and Madam Justice Jennifer Remy, retired High Court Judge. My lord, it is said that to whom much is given, much is expected. We, the practitioners at the constituent bars of the OECS, have been grateful and proud to be members of the Eastern Caribbean Supreme Court. I take this opportunity to congratulate the court on reaching a landmark 50-year anniversary of consistent high-quality judicial services, which has seen the court grow from strength to strength. We are especially proud to be a part of a court which is somewhat unique in that the Eastern Caribbean Supreme Court is a court serving 6 independent states and 3 overseas territories, a total of 9 jurisdictions. We hold the very unique position of having 1 Chief Justice, 1 Court of Appeal, and 1 Judicial and Legal Services Commission to serve all 9 jurisdictions. Despite the financial and travel constraints, our court has been able to consistently serve the 9 islands over the years, adjudicating on hundreds of cases and delivering scores of judgments. The Eastern Caribbean Supreme Court and the OECS Bar have enjoyed excellent relations over the years. In fact, the OECS Bar owes its very existence to the struggle for better terms and conditions for our judiciary, leading to the formation of the OECS Bar in 1989, some 27 years ago. And we continue to steadfastly advocate for better terms and conditions for our judiciary. While the court is celebrating 50 years, we must note and applaud the significant achievements of the court during these years, particularly the introduction of the Civil Procedure Rules 2000. These rules, as we've heard, completely reoriented our practice of law in the OECS, and we are still feeling the impact. In fact, after some 16 years, we still refer to the rules as the new rules. These rules were promulgated to create greater access to justice, provide greater certainty and transparency to the procedures of court. Other achievements include the institutionalization of judicial training and other forms of training at the levels of the court, from bailiffs to registrars to magistrates, the use of technology to enhance the work of the court, including the hearing of applications, the emphasis on case management to ensure a court-driven process and to minimize backlog, and the appointment of several masters to drive matters along and to make the case management system more efficient and the CPR rules more effective. Hopefully, gone are the days when we had to wait 10 and 11 years to complete a civil matter in the High Court. Mediation has been a big success story in the OECS. It is said that only Jamaica, which has mandatory mediation, leads us in the region in terms of court-connected mediation. Since its inception in 2004, we have literally resolved hundreds of cases through mediation process. We could not imagine the extent of backlog today had mediation not been introduced. With mediation, not only are cases resolved, but valued relationships of family, friends, and businesses are restored. Congratulations to the visionaries who introduced the rules of courts and court-connected mediation into the system. Further, the court has definitely been able to increase its efficiency with its compartmentalization into different divisions, including civil, criminal, commercial, and family. It's a continuing work in progress, but we are seeing the results. The commercial court in the BVI stands out as a major achievement. We also have the new rules for the criminal court being implemented throughout our jurisdiction in stages, which have proven to be a success so far, but nonetheless a work in progress. The court's website has been a welcome addition to the armory of the court. At the click of a few buttons, you can now access hundreds of judgments, from masters to justices of appeal, covering the 9 jurisdictions, not to mention scores of cases touching and concerning interpretation of the rules of court. We ought to be proud of the great jurisprudence and precedents that have been developed by our courts, which have been followed by courts throughout the world. And perhaps, for me, the most notable judgment of our court in recent time is one mentioned by the Honorable Chief Justice in Hughes and Spence, which overruled the once automatic application of the death penalty in capital murder cases. My Lord, judges of our court have served regionally and internationally, including the Caribbean Court of Justice and the Judicial Committee of the Privy Council. 2 of our past Chief Justices, Sir Vincent Flosac and Sir Dennis Byron, were also members of the Privy Council. Former Chief Justice Byron now serves as President of the Caribbean Court of Justice, on which court also sits former distinguished Acting Chief Justice Adrian Saunders. From May 2017, another former distinguished member of the Court of Appeal, Mr. Dennis Barrow, will be sitting on the Caribbean Court of Justice. We have Mr. Justice Kenneth Benjamin, a former High Court judge in our jurisdiction, is now the Chief Justice of Belize, and Madam Justice Sandra Mason is the Acting Chief Justice of Barbados. We have had a judiciary that has demonstrated true separation of powers by sometimes taking decisions that challenge the executive branch of the governments within the member states of the OECS countries. We have a court that has shown resilience, balance, and fairness in its judgments. A court that has not been subjected to open charges of corruption of its judicial officers. A court that has guarded and defended the rule of law in the OECS jealously. And a court that has truly held the constitutions of the OECS territories as omnipotent and indeed supreme. We at the OECS Bar cannot overemphasize the importance of continuing legal education, as we have strong belief that a strong bar, a disciplined bar, an ethical bar, and a quality court can be maintained through practitioners continuously restraining and retooling themselves, participating in seminars and being reminded of the standards that are expected of us as leaders and role models in our society. For the past 13 years, the Eastern Caribbean Supreme Court and the OECS Bar have been joining forces to hold joint symposiums at our annual conferences. They have all been huge successes. Such collaboration will continue at our upcoming 14th Annual Law Conference in the Commonwealth of Dominica in September 2017. We continue to collaborate in an organized and structured manner in bench bar committees already existing in several jurisdictions. In fact, we continue to actively promote and spearhead the formation of bar bench committees in every jurisdiction to facilitate the administration of justice, utilizing the collective energies of the bar and bench. Like the Eastern Caribbean Supreme Court, the OECS Bar has grown from strength to strength, promoting continuing legal education for our members, public legal education, professional indemnity insurance, and the establishment of legal professional acts in all jurisdictions. My Lord, let us continue to work together in the interest of the administration of justice. My Lord, with that said, however, we can't ignore that while we laud our achievements of a court celebrating 50 not out, we have to continue to identify our challenges and improve our shortcomings. Governments of the region definitely need to inject greater resources to facilitate the administration of justice. This has to be our constant call. It is worth repeating that we need bigger, better, and more modern court facilities throughout the OECS. We need better terms and conditions for the members of our judiciary. Real-time electronic facilities to transcribe our court proceedings, electronic filing, more specialized and support staff for our registrars, judicial clerks for all our judges, greater and cheaper access to online facilities for research purposes. The financial challenges that face the judiciary is public knowledge. More than 4 years ago, the OECS Bar submitted a comprehensive list of recommendations to the OECS Authority for decisions of heads of government regarding salary, pension, housing, security, medical benefits, and other progressive terms and conditions for our judges. We continue to follow up on the implementation of those recommendations. Progress has been painstakingly slow, but we continue steadfastly to press on. We do recognize that judges have to work under very challenging conditions, but a combination of proper management of cases, personal organization, and efficient delivery of quality judgments is critical to an effective judicial system. Effective measures ought to be put in place to ensure timely delivery of judgments. On the premises, my Lord, the OECS Bar has already suggested and will reiterate on this special occasion, that for us to have a true independent judiciary in the OECS, that the number of judges of the Supreme Court should be fixed at a number that meets the reasonable requirements of the changing needs of various islands, to be determined by the Chief Justice and the Judicial and Legal Service Commission, and not dependent on the concurrence of the Prime Minister or Chief Minister of the state, nor the financial ability of the states. In that regard, we call on the Prime Ministers and Chief Ministers, the governments of the islands of the Eastern Caribbean Court, to follow their own example in making funds available to set up a trust fund, as they did for the Caribbean Court of Justice, to be spearheaded by the OECS Commission. Such a trust fund has shared the responsibility of annual funding of the Caribbean Court of Justice. We believe that the governments of the OECS should no longer allow the OECS courts to be a burden and unable to fund its goals of an efficient and quality judiciary for all. Allow the court to independently decide the number of judges and resources that it needs in each island based on its own ongoing evaluations and caseloads. Let the refrain not be that the judiciary is broken, but the judiciary is awoken and is efficient. Talking about the Caribbean Court of Justice, my Lord, I think it's about time that we have a serious debate about the Caribbean Court of Justice. Not a debate on getting rid of our colonial past, and not a debate about we need to be truly independent, so we need to leave England, but a debate on the access to justice, which has been denied by the prohibitive costs of litigants going to England to the Privy Council. This can be good for our development of our jurisprudence and the quality of judgments coming from our courts. My Lord, on behalf of the OECS Bar, I say bon fete and free chairs to the Eastern Caribbean Supreme Court, and thank you all, the distinguished judges of the court, past and present, including the eminent Chief Justices we have had over the last 50 years. And of course, I am reminded that no milestone would be achieved without the inclusion of a strong woman, which we have in our first female Chief Justice, Dame Janice Pereira. We wish the court God's strength, blessings that would be needed to continue to steer the court through these challenging times as it continues its journey to another 50 years, but needing to be fully equipped to be more efficient and meeting the justice needs of our people and developing islands of the OCS. My Lord, much obliged.
Thank you very much, Mr. Antoine. We shall move on to the presentation of Mrs. Miriam Juliana Charles, who will now address the court on behalf of the St. Lucia Bar Association.
May it please the court. With your leave, my lords, my ladies, I would like to adopt the protocol already mentioned. With your leave, I recognize the presence of Her Excellency Dame Paulette Louisy, Governor General of St. Lucia, Mr. Michael Gordon, QC, Retired Justice of Appeal, Miss Jennifer Remy, retired High Court Judge. The Honorable Herman Gill Francis, Minister of Justice, who was with us a little earlier. As President, and on behalf of the Bar Council and members of the Bar Association of St. Lucia, I welcome this opportunity to add my voice to this celebration of the golden anniversary of the Eastern Caribbean Supreme Court. At the opening of the court in September last year, I acknowledged the success of our courts in terms of the jurisprudence developed out of the myriad cases which have emanated from our regional court, some of which have been upheld by the Privy Council, and the integrity and independence of our judges, which we have come to take for granted. I listed the several eminent judges who have served our court with distinction as Chief Justice over the years. While we can pat ourselves on the back for having capable and independent judges, this is not all that is required for the accessibility to justice and the delivery of justice. The law requires that criminal cases be heard in open court, except for in certain prescribed circumstances. Yet, even legal practitioners at times have been excluded from the courts on occasion. It is easy to believe that in these circumstances, members of the public have even less hope of being permitted to listen to a criminal case with which they have no direct connection. The civil courts are no more welcoming, as well-intentioned orderlies often exclude persons who wish to be present for a particular case. There is no justice behind closed doors. The courts are meant to be open to the public, and the bar must ensure that this right is not curtailed. While we have been given alternative accommodation, I was personally very involved in the massive effort which led to our old court building on Pena Street being refurbished. It goes without saying that a large sum of money was spent in this endeavor, but to date, the courthouse remains sealed like a tomb, with only a very meandering explanation from the relevant ministry that another location will be utilized, but no direct indication of the status of the air quality which we were awaiting. The status of the courthouse should not be a secret. The drama surrounding my membership refusing to go there was well publicized, and the bar is entitled to a straight answer. Although the justice system is usually seen as separate from the government, a poor functioning justice system reflects badly on the entire country. Hence our poor performance in doing business in St. Lucia, a vital component of which is the accessibility to justice. On that note, I must again mention the land registry, which continues to work only half-day amidst the usual complaints of photocopying not working and files unavailable due to the presence of mold. In making this complaint, we cannot be selfish and think only of our clients and our work. We must stand together in advocating for better working conditions for these employees, with whom we have to interact so often, as unfortunately, government after government fails to remedy the situation, and when air quality tests are received, they are suppressed. I'm asking myself why? Ask yourselves why. The magistrates' courts, through which all criminal cases must pass, are situated haphazardly all over the place. So while I am happy to take the credit for giving the last amendment to the jurisdiction of the magistrates' courts the final push in order to get it enacted, the question now must be asked: where will these additional persons who are now entitled to seek justice in the magistrates' court be housed? Imagine how many more cases must now be done in the magistrates' court, with the civil jurisdiction having moved from $5,000 to $25,000. In the entire court saga, it must be said that the magistrates received very little attention to their plight. Therefore, although today is a time for celebration, it would be dishonest for me, as president of the bar, to sweep all our woes under the bar table just to be nice. I owe it to my membership to represent them on all occasions and at all opportunities. I owe it to the registrars and clerks who work in the various registries to stand up in solidarity with them, because we depend on their assistance to be able to provide the service for which our clients pay us. We learned of the reopening of part of the forensic lab in the media. This ought to be of some value to our colleagues at the criminal bar, but we learned it by the way. I would like to use this opportunity to invite the Department of Justice to engage us, work with us in all matters concerning the law, because we have a vested interest in the success of any such project. So their success is our success. I have taken advantage of the occasion of the court's 50th anniversary to highlight some of our continuing problems so that we can try to address them together in order to serve the public better. On this note, I will continue to ask for God's blessings on the court, its judges, its officers, and on ourselves also, on the journey towards the goal of continuing to provide access to justice for the people of St. Lucia and the wider region, with the hope that this itinerant body will one day, in the near future, function from its headquarters in a structure of some permanence. I wish once again to thank the Registrar of the High Court, Mrs. Sharon Gardner-Hippolyte, and her staff for their tremendous daily support of members of the fraternity. In closing, I wish to salute our longest-serving colleague, Mr. Kenneth Montplaisir, Queen's Counsel, for over 50 years at the bar. Well, I had over before I knew that he was going to speak, so it's now 60 years. And I hope to embrace the opportunity of tapping on his legal experience soon. May it please the court.
Thank you very much, President of the Bar. We know that the bar is not asleep, it's well awake. Thank you for your remarks. And we also know that in this court, freedom of speech is alive and well. And no one will be condemning anything as fake news. We shall move on to the address of Ms. Diana Thomas from the Outer Bar.
If it pleases the court, may I adopt the protocol already established? As I am arriving at twilight, I would not wish to keep you longer than necessary. Permit me, however, my lord, to recognize the presence of Her Excellency Dame Paulette Louisy, Governor General of St. Lucia, Mr. Michael Gordon, Queen's Counsel, retired Justice of Appeal, and Madam Justice Jennifer Remy, retired High Court Judge. My lord, I am tempted to use that phrase that people accuse judges who have not done their work to do and say, I concur, because everybody has said what I intend to say, but the registrar will not forgive me if I do so. And so, my lord, I wish to highlight just very briefly those matters of significance which we at the Outer Bar consider to be the accomplishments of the court, and also 2 points that we are looking to embrace in the future. Of significance to us in the Outer Bar are the opportunities which arise from the paths that have been blazed for us by our predecessors. The OECS has produced some of the best and brightest legal luminaries the Caribbean has known. Even presently, the Caribbean Court of Justice is comprised of, and from my understanding, will be comprised of OECS judges whose intellect, independence, and mettle have been tried and tested. This circuit court runs like a well-oiled machine. Women are now at the pinnacle of the court. We truly live in a place where your advancement in the legal profession is not determined by what you look like or where you come from. It is determined on merit, how hard you work, and how disciplined you are. Other countries can only aspire to be where we are, and to think we are only celebrating our golden anniversary of the court's existence. To the future, access to justice by all, and in particular to our final appellate court, and 2, restoring faith and confidence in the judicial system by giving it the financial resources it deserves. I was at a charity dinner on Saturday evening for the Give a Heart Foundation hosted by the St. Lucia Medical and Dental Association. The keynote speaker was a cardiothoracic surgeon, Dr. Gary Stevens from Guyana. He highlighted a single and what in my view is a remarkable achievement by the Guyanese government in a public-private partnership by a leap of faith led by the then Guyanese president. Their motto, just do it. Whereas in 2004, it cost the government of Guyana $50,000 to send a single heart patient to Miami for medical intervention, by undertaking the Caribbean Heart Institute project within 18 months from 2004, it now costs US $1,500 for the same surgical intervention to be performed locally. Now, without equating the importance of saving a life to improving our judicial system, I believe this model is worth exploring. I have had the good fortune, or some would say the misfortune, of having appeared before the Privy Council twice during the last 10 years. On average, a client needs to budget 250,000 EC dollars multiplied by 2 for civil matter. And I say this because I know in 2007, tax costs fit for 2 counsel and solicitors or Privy Council agents amounted to £65,000. And then you must make provision for in case you lose the case. You have to pay that same amount to the other side. So your budget is $500,000. That sum, my lord, is the cost of a middle-income home in St. Lucia. In death penalty cases, the taxpayers foot the bill. All other persons who can't afford it, no Privy Council for them, they stop at the Court of Appeal level. I say this because from estimates, acceding to the Caribbean Court of Justice, located in Trinidad, will reduce that budget by about 60%. And so, my lord, the statistic that the Chief Justice gave that in 2015, 503 appeals were filed at the Court of Appeal level. We must ask, how many went to the Privy Council? And so, my Lord, my first submission today is, in short, is that the future we must embrace and encourage in very real money or cold, hard cash terms is that the OECS jurisdictions must accede to the Caribbean Court of Justice as our final appellate court. And may I now be permitted to address the executive and legislative branches of government. It seems to us that for years, the judicial arm of government has been treated like our feet, the least cared for part of the body. But my lords, the feet are just as important as the parts of government. Disabled persons who lose their feet have alternatives. They have wheelchairs, canes, and even prostheses. They go places without a feet. This social contract that we have entered into with each other under a constitutional democracy, we recognize is imperfect. The social contract is that we have agreed that when we have disagreements amongst ourselves, or if the legislative or executive arms of government go wrong, that a person of great intellect and integrity, a judge, will decide who is more right or less wrong. We have agreed that when we commit wrongs against our fellow men, persons of like intellect and integrity who are just like us, a jury, will decide whether we are right or wrong and determine our fate. We know that the judge may wake up one morning on the wrong side of the bed. They're human. The jury may be unknowingly affected by or disaffected by interaction with you or your family. Or worse, your lawyer who you have paid to represent you simply does not do the job. But this is the system that we have. Unlike disabled people who have no feet, we have no alternatives. And so, my lord, we cannot let that judicial system fail. And my lord, the common theme throughout the speakers who have spoken this morning is that we seem to be letting that happen. In my respectful view, my lord, a large part of the reason why communities now live in fear is because during the last 50 years, we have allowed the judicial system to slowly but surely be treated like feet. We do have a lot to celebrate, but the future we need to embrace is to put the judicial system back at the pinnacle of our society, starting with the edifice where the court is housed. We have wasted too much time. I believe it must be about 6 years where they're deciding where to put the court. Just do it. We must pay close attention to support programs offered by Intervention for Young People. Just do it. And my lord, it's strange that we are where we are, because I was very heartened to have attended the Independence Ball hosted by the Prime Minister last Tuesday. And the proceeds were in aid of the Upton Gardens Girls Center, which is a center built for intervention for women, for young girls at risk. And so, my lord, all of these matters, we have to take it into account. And, my lord, I speak here for the utter bar when I say, my lord, that we are heartened by the words of the Attorney General, who, when I had written this, my intention was to ask the Attorney General and the Minister of Justice to take the words to the Minister of Finance, but they have already done so. And so, my lord, all of the hard work that needs to be done, we really do hope that they take these words seriously. And my lord, I am humbled by the opportunity to address this distinguished gathering on this august occasion on behalf of the utter bar. And my lord, unless I can be of any further assistance, thank you.
Thank you very much, Ms. Diana Thomas, on the behalf of the utter bar. Thank you for your address. We will now move on to the address from the bench. On the behalf of the bench, we will be hearing from Justice Georges Taylor Alexander, High Court Judge.
Thank you, my lord. Good morning. In the interest of brevity, I wish to adopt the protocol list that you had eloquently established this morning when our proceedings started. However, I wish, with your leave, to recognize the presence of Her Excellency Dame Calliope Perlet Louise, the Governor General of St. Lucia, retired Justice of Appeal Michael Gordon, Queen's Counsel, retired High Court Judge Ms. Jennifer Remy, Assistant Superintendent or Commissioner of Police, I apologize, Milton Daisy. In a recent communique by the Honorable Chief Justice, Her Ladyship reminded us all that as we celebrate the milestone of the 50th anniversary of the court, we must remind ourselves that this is our court and therefore our achievement. The significance of this statement must be underscored, as in there is an acknowledgement of our historical past, entrenched in colonialism, and more importantly, an appreciation of our struggle to assume control of our lives as an expression of our sovereignty and in control of our destiny. In order to fully appreciate the statement of Dame Janice, I thought it prudent to do a brief examination of the historical background and creation of the court, to catalogue its development and achievements over the years, and to assess its strengths and future direction. The current construct of the court emerged from the former Windward and Leeward Islands Supreme Court, as you heard our chief make reference to, and also from its brief stint as a federal Supreme Court under the now dissolved Federation of the West Indies. The failure of the Federation is a matter of historical record, but consequent on its failure, the court created under the Order in Council also fell apart in 1962. In 1967, the West Indies Associated States was created, and by the Order in Council, it was given effect, and also under our various constitutions. The initial territories the chief made reference to comprised Antigua, and now Antigua and Barbuda, St. Kitts and Nevis, or St. Christopher and Nevis, and Anguilla at the time, Dominica, Grenada, St. Lucia, St. Vincent, now St. Vincent and the Grenadines. It was at a time when in the English-speaking Caribbean, governance was impacted by the weight of a colonial past. All of the islands shared a history of conquest, settlement, and colonialism. The British had ruled our region for close to 400 years, and that had left an enormous influence on our political and legal landscape. As the island nations struggled with their own identity, independence movements gained momentum, and each territory began the task of creating their own constitutions and legal systems to establish their self-rule, distinct from a colonial past and marked with its own unique identity. It is against this backdrop that our court developed, by a people anxious to create their own history, representative of their own culture, and to eventually develop their own jurisprudence. A hallmark, therefore, of this new creation was that it was constituted by men and women who were all regional persons born and bred. That at that time we entrusted the success of this institution in our own, despite our failed history with the Federal Supreme Court, showed our belief in our ability, our commitment to writing our own story. The first Chief Justice, as you've all heard, was Sir Alan Lewis of St. Lucia, brother to St. Lucia's Nobel Laureate in Economics, Sir Arthur Lewis, and father to former Prime Minister of St. Lucia, Sir Vaughan Lewis. For those of you who do not know, he is the father-in-law of one of our members of the bar, Lady Shirley Lewis, who I think is present today. He was assisted by two appointed Justices of Appeal. The first was Sir Keith Gordon of St. Lucia, brother to Sir Garnet Gordon and uncle to retired Justice of Appeal Michael Gordon. The other Justice of Appeal was Justice Percy Lewis of St. Vincent. The first judges of the High Court were Elwin St. Bernard of Grenada, Sir Alan Louisi of St. Lucia, a former Prime Minister of St. Lucia, Eric Bishop of Barbados, Eardley Glasgow of St. Vincent, and Sir Neville Peterkin of St. Lucia, I believe father to well-known Richard and David Peterkin. Thus began a course and a path to map our own history. The court has undergone changes in its form over the years, as for example, the change in the way the court was styled from the Associated Supreme Court to the Eastern Caribbean Supreme Court, following the changes promulgated by the Treaty of Bastille. Increases in the number of judges servicing the Court of Appeal and the High Court, and the activating of the masters as judicial officers of the court. we can perhaps mark with commas certain events along our development that contribute to the story of who we are and where we are today. The inclusion of the British Overseas Territories, British Virgin Islands, and Montserrat that increased the court's membership to 9. The exit of Grenada following the overthrow of the constitutionally elected government of Eric Gairy in March 1979, and the suspension of the Grenada Constitution until I believe it was 1983. Over the years, each of the territories' individual goals, values, and strengths have metamorphosed into shared goals, shared values, and shared strengths, precisely in accordance with the vision of our forefathers. We continue to learn from each other and grow closer together through our shared jurisprudence, deepening our integration and cooperation that reflects the history and the values of our shared territories. As we grow closer together, we truly are fulfilling the objective of being the architects of our own destiny. Over the years, the court has undergone significant changes, all designed with the intention of increasing its efficiency and improving its service to you, the public. I'm sure you will agree that there are many successes we can discuss, even as we continue to face many challenges. Some of the successes are the implementation of the civil procedure rules, which speakers before me have alluded to, in 2000, and I agree, no longer to be referenced as the new rules, which was a period I recall of intense anxiety for most private practitioners and which changed the manner of practice from practitioner-controlled to court-controlled litigation. It commenced first with status hearings, most of you would recall, under the very stringent management of Justice Barrow, designed to reduce the backlog of our old matters stuck in and clogging the system. Despite pushback from the practitioners, the court forged ahead. The rest is history, but ultimately the benefit has redounded to the public, who has been given more certainty of speedy trials, eventual judgments, and a more participatory process. The activation of the Master of the Supreme Court in order to give effect to the court's case management objective. This commenced with our first 2 masters being the former Chief Justice Hugh Rollins, or Sir Hugh Rollins, I stand corrected, and Master Charmaine Pemberton, now Justice of Appeal Pemberton of the TT Law Court. The implementation of technology as a tool in the efficient delivery of justice. This saw the implementation of the GEMS software, the implementation of our CAT units, VideoLink, and e-filing, all of which had been referenced by Mr. Theodore Queen's Counsel, all necessary to suit a court that operates as a single court in multiple jurisdictions. The establishment of the Commercial Division of the High Court in May 2009, with 2 such courts now being implemented in the BVI and in St. Lucia. The implementation of the Criminal Procedure Rules under the pilot in St. Lucia in an attempt to introduce case management and to reduce the backlog and delays in the trial process. The introduction of mediation with tremendous success, as had been alluded to by the Chief Justice this morning. And the appointment in August 2012, I believe, of our first female Chief Justice, Dame Janice Pereira, who continues to serve with unparalleled distinction. The establishment as well of a practice and procedure for the appointment of Queen's Counsel, which hitherto had no identified procedure. For this process, over the last 2 years, there have been appointments of well-deserving Queen's Counsel. These successes have not come without challenges. All that I have alluded to shows that over the years the court has embarked on an ambitious agenda to reform and to make strides to expedite delivery of justice to the citizens and to reduce bureaucratic and technical delays that disenfranchise the public whom we serve. The economic trials of all our territories have threatened to undermine the court's sustainability. It has forced us to operate with limited resources while still remaining productive. Our caseloads increase steadily. The court struggles to maintain its efficiency with the available resources and to continue to give effect to its original objective as envisaged by our forefathers of a court of our people, for our people, and dedicated to the improvement of the lives of the people of the OECS. What then is the future of our court? Our Caribbean jurists and academics continue to stress the importance of developing a Caribbean jurisprudence through our courts and in the creation of our own institutions. The OECS Secretariat has been instrumental in fulfilling that objective by assisting the territories in drafting uniform legislation. This has enhanced our integration process. The commitment to the original objective clearly remains. What probably has differed is the means to get there. In recent times, Dominica has adopted the CCJ as its final court of appeal. And I monitor the challenges that our Court of Appeal may eventually have to face in reconciling different judgments and opinions on identical issues from two final appellate courts. This may well challenge the principle in Young and Bristol aeroplanes of standing by one's previous decision. I wish to assure Mr. Theodore that not only in this jurisdiction of St. Lucia have we implemented or do we have the capability of video link, but in fact it is a daily part of our operation, so that it is now the usual practice for inmates at the Bordelais Correctional Facility to be heard via video link for most pretrial hearings, bail, and sentencing hearings. We are all equipped with iCloud, and we use it regularly to back up our judgments. The Liberty software is still in teething stages, and once all the glitches are ironed out, that too we will be effectively utilizing. And so we do not limit ourselves by the limitations of our physical environment. Our challenges, however, continue. These have been eloquently established by the speakers before me, the Honorable Attorney General, the Honorable DPP, Mr. Dexter Theodore, Queen's Counsel, the President of the Bar Association, the President of the OECS Bar Association, and so I need not make reference to them. Our task continues to be formidable. I, however, believe that if we remain committed to and strive to attain the vision of our forefathers, those challenges too we will overcome and grow from. Our history has been measured, practical steps, and we continue to draw comfort from the strong reputation we have built and from our persistent shared vision and unending commitment to the creation of our court. I congratulate you all, both my colleagues on the bench, the bar, and the general public, on this milestone, and we look forward to working with you and the court over the next 50 years. Thank you.
Thank you very much, Justice Georges Taylor Alexander, for your presentation. On behalf of the bench, I'm sure that I speak for all of us when we say that we very much appreciate your having taken on that task on our behalf. And at this time, I have to, first of all, express thanks to all of my fellow judicial officers, judges and magistrates for your presence here today. Of course, I also recognize the presence of Her Excellency and express my thanks for Your Excellency to make it possible to be here today. I have noted that in the original protocol list, I did not mention the presence of Justice Jennifer Remy, retired, and the Acting Commissioner of Police, Mr. Milton Desi, who I welcome to these proceedings. Thank you very much for attending. I have to respond just very briefly. I do not want to keep you much longer. to what has been said. I must say it has been a remarkable morning. It rose to expectations. I guess that in spite of the saying you only live twice, the likelihood is that you will only celebrate your 50th once. And I think that everyone who spoke today showed that they appreciate that there would only be one 50th. And if they ever are to make that effort to make it a special occasion, they made it today. Thank you all for your special effort. I want to commend you on your research, starting with the very first speaker. Who would have thought that someone would have gone to look at a newspaper from 1967 to reflect on the words of the court at that time? Thank you for your insight, for your ability to analyze what is important as we look at what is happening to us today. As once someone said, who would have known or who would have thought that 50 years later we would have to be borrowing premises to have this occasion. Thank you for the depth, the historical depth of Mr. Kenneth Montplaisir, Queen's Counsel, who was the only one present who could have made the presentation that he made. And we know that there is a lot more that he could have said. And I hope that all of us have an opportunity to hear that, probably over drinks. Thank you for the advocacy, at times fearless, coming from the president of the bar of St. Lucia. And I think that, what more can I say? But I very much appreciate, I think that all of the members of the judiciary very much appreciate, and all the members of the bar very much appreciate the bar rising to its role and speaking on the behalf of its members, but indeed going beyond that and speaking on the behalf of the community which the court serves. So how can I sum it all up? I would say it has been brilliant. And I therefore feel that in response, I have every right and duty to make an order that the transcript of these proceedings be made available to the public, free of cost, if not free of cost, at the most limited fee that can be feasible in these circumstances, preferably free of cost. If that has not already been decided, let it so now be decided that that transcript shall be made available, so that all and sundry can have an opportunity to read it and appreciate everything that has been said today. Not only a recitation of history, but an appreciation of history and of the moments, special moments, and the significance of where we have come from, and the insight, especially, and foresight coming from those speakers like Mr. Theodore as to where we will go and how we will get there. Thank you again for this very, very memorable occasion and the presentations from all of you who have been speakers this morning. I am also asked to make a special mention of staff for this occasion, staff who have worked at the Registry of the Supreme Court, who have provided long and outstanding service. And if you are here, as I mention your names, please stand so that all can acknowledge your presence. I am told that at a later occasion, I'm not sure if today or sometime later, the recognition will be made more concrete. I start with Mr. Vitalis, the binder, for 35 years service. He's not here. Mr. Thomas Louis, the vault attendant, 24 years service. Mrs. Bernadette Amédée, court administrator, 23 years service. Ms. Jennifer Ogis, clerk of court, 34 years service. Mr. Andre Baptiste, court administrator, 24 years service. And Mr. Richard Smith, clerk of the court, 24 years service. I'm also asked to mention that the donations have been made for our appreciation, providing lunch and dinner for these members of staff who have been mentioned from the law firms of Flozak and Fleming, Gordon and Gordon, Mrs. Mary Juliana Charles, and Mr. Peter Foster, Queen's Counsel. Thank you again all for having made this such a memorable occasion. I am told there's more to come. Please keep your ears open for all of the information that will be released in relation to further events for the celebration of the 50th anniversary of the court. As we rise to adjourn, I am told to remind you that there is a reception following at La Place Carénage, at the premises of the court, at La Place Carénage, after the sitting. Without further ado then, all rise.
Well, this has been the live broadcast of a special sitting to mark the 50th anniversary of the Eastern Caribbean Supreme Court. The session was held right here at the Parliament Chambers. It was preceded by a simulcast address delivered by Her Ladyship, the Honorable Dame Janice M. Pereira, Chief Justice of the Eastern Caribbean Supreme Court. Members of the legal fraternity were honored by the presence of St. Lucia's Governor General, Excellency Dame Paulette Louise. Retired Justice of Appeal Honorable Justice Don Michel will be delivering one of the anniversary activities today in Antigua, and this is why Justice Pereira is not here today, because she will be attending that event later. Several challenges and of course a milestone achievements were highlighted today, and some of the challenges is that there continues to be a backlog of cases in the court. Also, President of the St. Lucia Bar Association highlighted the fact that the High Court is still under construction, and so there needed to be some more open and frank dialogue on where the court is going, as she believes that there needs to be a permanent home for the court. Among the many achievements of the court, we were told that St. Lucia had 7 resident judges, comprising 4 criminal judges, 2 civil judges, and 1 commercial judge, and that the court is now supported by a distinct administrative arm. The number of backlog cases have been reduced significantly because of the installation of masters and judges, but a lot of work still needed to be done in that area, we were told. Throughout this year's anniversary, several activities will be taking place. The essay and poster competition. There will also be an exhibition at the Castro City Hall, and also a gala dinner. Several activities will continue throughout the year, not just concentrated on this day, but throughout the year. Members of the public will be invited to support several of those other activities. And the court, we were told, has implemented the civil procedure rules, alternative dispute resolution and mediation, and also has embraced changing technology to the extent that they've now implemented digital audio technology and video link in the court. So there's a lot to be proud of, despite the many challenges being confronted by the courts. Well, the members are now making their way out of the Parliament chambers for a follow-up reception. And so we at GIS and the National Television Network want to thank you for being part of this broadcast as we bring you the subsequent activities of the court in some other broadcast. We want to thank you for watching. Goodbye.